Criminal, week 4. We only had one class this week, so there's not much to it, but there was a presentation on Friday by the Chief of Police last week. And then on Monday we reviewed some of Hart and Devlin and started talking about marijuana and a couple cases related to that, which relates back to the harm principle and the debate between Hart and Devlin. So the Chief of Police talked about a few things, one of them being the public impressions of the police as a helpful part of the community, or as I guess a problem in the community. She mentioned, I think his name was LeBlanc, writing about perhaps borderline slanderous things about police officers on his blog, and how they arrested him and how that was unlawful. And anyway, and that led into a discussion a bit about police dealing with citizens who have mental exceptionalities. But she highlighted the fact that the police need to be respected and seen in a positive light in order for them to serve their function. And also how, as their roles change over the years, how that is sometimes difficult for the police the people who are policing, to handle kind of a change in roles and change in duties. She talked about the Initiative for Domestic Violence and how many of the assaults, or a large majority of the assaults that happen in Fredericton, happen within the context of domestic violence, and so they're developing more standards of how to deal with these and more training initiatives for their staff, such as, you know, if there's a woman at home and you show up because her window has been vandalized, well, is that a sign of domestic violence, or is it just someone breaking the window? And she went very thoroughly through their strategic plan, which dealt with forming categories, dealing with their interactions with the public, their internal management, their staff development, and I'm not sure the fourth one, but went into great detail about that. And lastly, they had a focus on the officers. This strategic plan came out of the fact that there was a lot of police officers who were unhappy with their union, with the leadership in the police department, and they went to the newspapers and complained, and so that led to a lot of group sessions and facilitated meetings to figure out what needs to be done in order to address the situation. And she also mentioned that that's a problem, because if the community thinks there's conflict within the department, then how can they, possibly deal with conflict that is happening in the community? So moving on to Hart and Devlin, we talked about this a little bit in tolerance, the idea of tolerance in society. So is the law reflective of the societal values, or is it prescriptive? Does it kind of push societal values along? And generally it's both. Sometimes it reflects things, and other times it propels measures of tolerance. And the best example I can think of is the Charter of Rights and Freedoms, and some of the guaranteed rights that arose out of that document that maybe they may have been perhaps a little before their time. So continuing on with Hart, his reaction to Devlin is that Devlin's reaction against a rationalist morality, so rational meaning, with reason, an objective way to measure the harm that's done, a rationalist morality, and his stress on feeling. He has thrown out the baby and kept the bathwater. The bathwater baby turned out to be very dirty indeed. Just kind of summarizing the difference between the two. And we talked about Trudeau a bit, and him repealing the laws on buggery and gross indecency, and was that based on the moral justification or the harm principle? And of course, it's based on the harm principle. Moving on to marijuana. So the key here in the connection to Devlin and Hart is, can the harm principle be used to justify the criminalization of marijuana? Is there enough moral justification to prohibit it, or can you use moral justifications to prohibit it? So when this was brought to court, it was brought in 2 cases in 2003. Malmo was one and Kane was the other. And they said that it's just their responsibility to determine the constitutionality of the legislation, or to determine the constitutionality and not to judge the content. Is this claim convincing? I think so. I would tend to agree with them. So, is the law prohibiting marijuana a valid exercise of the jurisdiction of the federal government, as stated under 1927 of the Constitution? And yes, they're protecting public health, it's a national concern, and there's a penal aspect. So they're perfectly constitutional in their prohibition of marijuana under their criminal jurisdiction. So Malmo Levine was arguing that laws against possession for the purpose of trafficking are unconstitutional. That is, they violate the Charter of Human Rights and Freedoms. And Kane was arguing that punishment for victimless crimes are counter to fundamental principles of justice, and here he was referring to the harm principle. And both these arguments were denied. So let's look at the majority. The decision was 6-3, Gontier and Binney speaking for the majority. And they noted some justifications for the Narcotics Act. So just looking at the constitutionality of the Narcotics Act. So they mentioned that there are people who are vulnerable to marijuana, people who are suffering from addictions, pregnant women, people with schizophrenia. And so this is a broad policy to advance protection for those vulnerable people. They mentioned there's no mandatory minimum sentence for possession, and jail is generally only reserved for traffickers and those who use harder drugs. It could be argued that criminalization of marijuana is unwise from a policy perspective, but that's not their job. Their job is to determine the constitutionality, and it's constitutional. They also talked a bit about the harm principle and said, no, it's not a principle of fundamental justice. It's an interest of the state. And the absence of proven harm does not create an unqualified barrier for legislative action. So just because there is no harm, which is very subjective, that doesn't mean that they can't create a law against it anyway. Mostly because it's not prohibited to criminalize harm to oneself. Suicide is illegal as one example. So basically, there's no consensus on the harm principle as a principle of fundamental justice. And we have many laws counter this principle. They did mention, though, that you could argue that imprisonment, that the punishment aspect of the law was too severe. So perhaps not that the law itself is unconstitutional, but the penal aspect of it is too severe, but they didn't argue that. Dissenting, Arbour takes a strip off the majority and says imprisonment, and here she's talking about the penal aspect of it, can only be used to punish blameworthy acts which harm someone else. If you imprison someone who has not harmed anyone else, you are violating their Section 7 Charter rights. So she agrees with the plaintiffs in this case. She talks about balancing the harmful effects of the act with the harmful effects of prohibiting certain acts by threat of imprisonment. So, both those ideas are not ideal, I suppose. So is the cost of enforcement worth the benefit of prohibiting the act? And is the cost of decriminalization worth the benefit of non-enforcement? And Arbour here notes the impacts of marijuana on the average citizen and says basically it's harmless. She also mentions, interestingly enough, that the vulnerable people that this law is meant to protect also threatens them with imprisonment for harming themselves, which is, questionable. So her conclusion is that the cost of prohibiting the act is too high for the benefits we receive, as there is little reason to risk society. Thus, Section 3.1 and 3.2 of the Narcotics Act violate the appellant's right to liberty under Section 7 of the Charter by virtue of violating the harm principle, which is a fundamental principle of justice, so says our law. And that's what we learned in criminal this week.